Stand ready for the second case of this session, 24-1954, State versus Cruz. Good morning. For the appellant, Mr. Cruz, we have Alfredo Parrish and Alexander Smith. Mr. Parrish will be arguing. And for the state, we have Joe Ferrentino. Thank you. Whenever you're ready.
Chief Judge Tabor, and may it please the court, Camden Academy and the Bulldogs. Above my desk in my office is a piece of art I bought probably 30 years ago. And it says there's a human figure in that piece of art floating in the air. And it says, "May you always believe in the art of magic." In this case, there are magic words that were said by Mr. Cruz, not just once, but over 15 times. I don't want to talk anymore. And when you read the decision and the follow-up in these cases, it makes you lose faith in that art of magic. They have magic words that you can say, even though they don't have to fit into a certain category, to alert law enforcement officers that you don't want to talk anymore. When you say such words as, "Give me a lawyer," "I don't want to talk anymore," "I'm done listening," "I don't want to talk anymore." Those are magic words, even though this court has consistently said that there doesn't have to be set in a particular category and a particular manner.
Cruz take some of that magic away when he kept talking after he said those things?
Looking at the totality of circumstances, that's a good question, Judge Betting, but he did not. You look at the fact he admitted that he was on methamphetamine, he was nervous, he was highly emotional, talked about how much he loved his wife when he was making these statements. And you look at the time when they take a break and go to the bathroom for about 11 minutes. The officer is the one who said, "Let's go to the bathroom and we'll take a break." He could recognize how emotional he was. And I'm not saying this was some kind of trickster or something like that. That's not the case. But he took the break because he was an experienced law enforcement officer, Mr. Under, who then took the break after he made it clear he didn't want to talk to him anymore. And who was the person who initiated the questioning when they came back? The district court judge really missed this in his ruling, about 5 pages, and didn't quote any cases in that manner. He says, "Is there anything else I can help you with?" He reinitiated the questioning. It's been clear that once you stop talking, and he knew Mr. Cruz had stopped talking at that point, he knew that this conversation was over. That's why he took the break. You'll have an opportunity, obviously. The district court judge did not have that opportunity, and I've looked at it so many times I've gone blind almost and listened to it. You can see it and hear it. The district court judge only had the opportunity of hearing one audio and seeing one video. He saw the video from Minnesota, and then the audio was coming in from Hancock County. Yes.
Cases distinguish, as far as officers questioning and statements between those that are sort of the normal part of custodial process and those that are trying to elicit statements. Why is, "Okay, Roger, anything else you need," trying to elicit statements from him rather than, checking on, his status kind of more in the routine standpoint?
That's a great question. Yes, there is a distinction made. However, in this case, if you add up, the 16 or 17 additional times he makes the statements, "I don't want to talk," you have to put that in the totality of circumstances. But there's also another element you have to look at here, and that is the district court judge ruled that he was in custody at the time. He just didn't rule that he had equivocally asked for counsel. But I don't know what else you can think it to mean except "give me a lawyer," except the state's in his brief talks about the fact, well, they almost go off on a kind of self-analysis type of thing about the statement. But it's clear, Judge Langholtz, that it was not unequivocal. It was equivocal each time he made the statement about, I don't want to talk anymore. Truly, to go back to Judge Batting's question, it was emotional. He'd said he was on methamphetamine. He had just taken methamphetamine. So if you look at all the factors, including the fact he kept evoking he was in love with his wife and how terrible stress he was under, you have to look at all of those factors before you can reach the conclusion that he did not ask for his right to silence. He did clearly ask for that.
Correct, and these statements should have been excluded from the trial. Could you talk a little bit about the harmless error? Like, how would the strategy have been different?
I knew we would get there at a point. But interesting enough, the harmless error, I know both you and Judge Batting were on the Park case that the Iowa Supreme Court reversed, but this is a mixture between the Park case and the case I just love, the Walls case. The reason I love the Walls case because it has Justice Baker and Justice Cady in his dissent battling about the issue of the harmless error. I think that's a fabulous case for anyone to read, and these two incredibly justices talking about it. And to get to your harmless error issue here, two factors in the Park. Let's look at the Park case. The Park case was all pre-trial. I know our office argued that issue, but in the Parks case, they're talking about pre-trial, how it impacted. Our case is much stronger in the Cruz case than the Parks case because she went down to the place voluntarily. Then how do you look at the harmless error in that case as opposed to the Walls case or opposed to the Cruz case where he's actually in custody and the actual excluded evidence, or we think the erroneous evidence went into the trial. So it's kind of a mixed analysis that I think you have to do here. Let's look at Parks. How did that impact her trial preparation, the strategy, whether or not she files additional motions, whether or not she hires experts? That's how you have to analyze it from the Parks standpoint. And again, factually, we're on a lot better grounds than I think Parks was when she made the motion and you all ruled favorable for her, although it was unfortunately reversed by the Iowa Supreme Court. In this case, you have Cruz, where you can take his statements and look what the prosecutor did with it. She talks about it in her opening statement. She plays it at one point, they take a recess, and the judge says, well, this is going to take an hour and 47 minutes because we know we're going to get to the critical point. But also, the state did not object to the finding, so which I think is significant for you to consider because I think it's a waiver on their part. But in Cruz, if you take out those statements that are particularly related to the defendant, we all know that every jury wants to hear from the defendant. What did they say? When did they say it? Under what circumstances? What were they acting like? Sitting there in an orange jumpsuit?
In this case, the statements up until the invocation, like that he wanted the officers to check on his wife, those would have still been admissible.
No doubt about that. But you go to the right to counsel, which we think was violated later. After he had counsel, they appointed him the public defender, and then later he hires Attorney Riggs to come in for him on the 20th, I believe, of November, and he had the public defender, I think, appointed on the 2nd of November. When those things happened, they had no business talking to him anymore because they talked with him when they knew he had counsel, didn't contact his counsel. I wonder what they were thinking when they got to the issue. If you can't afford counsel, the state will appoint you one. They knew he had counsel. What kind of statement is that to ask in the Miranda warnings? It doesn't make any sense.
Though, I mean, he asked to meet with them. You know, he told the jail staff, I want you to come. And for the first hour and a half, I mean, he pretty much talks nonstop. I mean, the agent, you know, empathizes and says, I understand, and maybe asks, you know, what evidence do you have of this? Or, you know, very kind of clarifying questions. And then, at least as I kind of listening to the tape, it sounds to me like the murder gets brought up first, unprompted by Mr. Cruz. So how, under our precedents that, you know, there can be waiver of the right to counsel, or Miranda for that second one, how is that a violation?
One little step, and I called Mr. Rigg to push him on this issue. There's one little snippet in there where Eli goes into and he tapes into his tape recorder and he says, I'm going to talk to him about the murder. Now, clearly, Mr. Cruz starts rambling on about all of these other incidents, but what he's really in there for is to find out what else he's going to add to the issue of the murder. So that's how you get by it, by saying it was a right to counsel issue. You don't even have to get into, I think I'm running over my time, you don't even have to get into other aspects of it. It was a clearly right to counsel issue, but you also have to go back to when he invoked it back in October 28th. Thank you, Your Honors.
May it please the court, counsel. I'm a transplant from Michigan, Whitehall High School from Whitehall, Michigan. Go Vikings. I'd like to begin at the end with harmless error. And the evidence that we have that Mr. Cruz killed his wife is overwhelming. To begin with, we have the medical examiner's report that this was a homicide. The medical examiner also found that the cause of Ms. Cruz's death was blunt force trauma and strangulation. We have the video footage of Mr. Cruz tearing off the Ring camera that morning. We also hear him in the backyard calling for his dog from a different video. We have two different confessions to Ms. LeBlanc and to Jana. Janice tells the law enforcement in Minnesota that when they do the welfare check on Karen, that they'll be arresting Mr. Cruz. Francine testifies in great depth to the nature of the confession at trial. We also have that voicemail to Francine where he says, I'm finally free, and he appears emotional, and I think we can infer from other facts in the case that he's planning to commit suicide at that moment and leave the dog with her. He shows up at Francine's house sweaty, with his hair plastered to his face, with blood on his hands. And we have the footage of the bonfire, and we know that there were burned shoes in the bonfire. We have Deputy Klein testifying about the jail phone calls he made in which he remembers different aspects of the crime as time goes on. And the other thing I want to emphasize about this harmless error argument is that their trial strategy was not going to change at all. Before the suppression ruling was even made, there was a notice of possible defense filed. That list diminished responsibility, and it also mentions Dr. Bruce, who was ultimately their expert at trial. So the plan here was always to argue for murder second and maybe hope for a manslaughter, but really I think the realistic expectation that the defense had was murder second, which is what they ended up getting.
It's an argument in the brief that harmless error shouldn't apply here, at least I guess for the right to counsel claim for the second interview because of sort of seems to be kind of a riff on structural error, I think. But what's your response to that argument?
Cooley for that argument, and they contrast it with Hensley. Hensley is sort of like there can be, for constitutional rights, there can be harmless error. Cooley sort of says not so much. Cooley is a Ferretta case, and it has to do with rights at trial. And in Cooley, our Supreme Court cites the U.S. Supreme Court in Patterson v. Illinois, and I'm just going to quote that. They're talking about post-indictment questioning, and they say the full dangers and disadvantages of self-representation during post-indictment questioning are less substantial and more obvious to an accused than they are at trial. So Cooley, citing via Patterson, is distinguishing these two situations where we have a Ferretta inquiry at trial. We think that's the dangers are more substantial and less obvious versus in post-indictment questioning, not so much. So I think we're still on board with any harmless error argument that you might have in any other constitutional case. I did want to touch on your question, Judge Langholtz, about the timeline of the second interview, because to my ear, it was Mr. Cruz who brought this up himself. I have at about an hour 7 into the interview, he mentions the quote accident or tragedy that happened. Then he goes on to discuss someone commenting on her obituary. He talks about the divorce, he talks about her internet habits, and from the discussion of her internet habits, we lead into questions about the iPad, and it's, you know, he's very willing and ready to talk about the iPad and its contributions to this case from there.
Some merit to the defendant's argument, though, where, you know, the officer clearly knew that the defendant was represented and had some sort of motivation going in there to talk to him about the murder. If I were his defense attorney, I would be livid if this happened with my client. So how do we, I mean, it seems underhanded in a way, although I know that he asked to speak to the police.
He asked to speak to the police. Agent Eli does read him Miranda, which says you have a right to remain silent, you have a right to an attorney. Mr. Cruz offers, you know, it doesn't work like that, like you're saying, you know, I do still have to pay for my attorney. When, you know, so for this, I would look at Johnson, which I cite briefly in my brief. The different factors that Johnson considers include whether the suspect initiated the conversation. That cites that Carter case from Maine, and so here Mr. Cruz did initiate. Johnson discusses whether the police had agreed previously not to interview the suspect without their lawyer present. I don't think there's any record of such an agreement in this case. There's no diversion or trickery. You might call this underhanded, but I don't think there's any trickery into getting him waive his rights. There was some indication that Cruz was relying on the advice of counsel not to talk, so he says, I'm not supposed to tell anyone anything, but you know what, I don't lie about nothing no more. So that one I would agree is in their favor. It's a free-flowing conversation, and he didn't ask to cease the conversation. So on balance, apart from that one indication that he was told not to talk, he does go on to talk. And I don't think that this multi-factor test is intended to privilege the idea that just because his attorney told him not to talk, that he's not allowed to waive that right. We don't conceive of these things as that kind of paternalistic test. It's one factor among many, and on balance, it allows him to waive it here. So I guess I would agree with you. If I were his defense attorney, I would be livid because this is not the correct strategy, but I think it's permissible.
Bit about the first interview and the invocations.
Yeah. So I think of the invocation differently than a lot of people do. Some, you know, it's either, but to my mind, it's either an unambiguous invocation followed immediately by a reinitiation, a waiver, or.
I mean, I count at least 8 times when Mr. Cruz says, I'm done here, give me an effing lawyer, I'm not effing talking to you no more, I'm done talking. And it seems like each time there isn't like a respect of those magic words. Like the officer comes back and says, but I have more questions to ask you. It seems like the reinitiation's on the officer's part when I read the interview.
I guess I don't think of them as magic words. You know, Davis invites us to ask whether this is a real request for an attorney. Let me pull up the exact language. In light of the circumstances, we would have understood only that the suspect might be invoking the right to counsel.
Effing lawyer? Like how much more direct would he have needed to be?
Give me an effing lawyer, this is sick, I ask you, is my wife all right, and you don't even effing tell me. I think that complicates the idea of whether that's an unambiguous request for counsel, because it's really what he wants someone to do is answer his question. He's interrogating Onder more than Onder is interrogating him at that exact moment.
Smith v. Illinois, the U.S. Supreme Court case, you know, it tells us we can't look at what comes after the invocation to decide whether the invocation is ambiguous. And it sounds to me like everything kind of to make it ambiguous is stuff that comes immediately after. Am I missing anything sort of about what's before and only what's before that would make it ambiguous?
I think what's before is, you know, immediately before this break, there's some discussion about how the officers in his home county, or the deputies in his home county, have wronged him. And I think he's on edge and is upset with the officers. That's why I sort of read the give me an effing lawyer is, it's fun to speak like this in this courtroom. It's almost like he wants to sue these officers, or he wants to punish them in some way, is sort of how I read it, in light of what just came before, meaning he's fed up with law enforcement in general, and he wants to assert some sort of some sort of right against them. He's not looking for a Miranda shield the way we think of it. He's doing something a little bit slightly different there.
Inject a lot of uncertainty into officers' dealings with defendants. You know, if we're saying like, he said he wanted a lawyer, but, you know, the context said he didn't really mean it. Don't we want a bright line rule here?
I think a bright line is useful, but I think that Davis says in light of the circumstances. And so when you say in light of the circumstances, I feel like that's a broader test than, you know, I'm done, give me an effing lawyer. If that's all he said, I would agree that that is unambiguous, but he says more than that before and he says more than that after. And I think that raises some ambiguity in the question. But even if you don't agree with me about this ambiguity question, when he's asking, will you answer my question, or you don't even answer my question, that suggests to me an immediate reinitiation and an immediate waiver of any assertion or any invocation that he's made as to his right to counsel. Because now he wants the conversation to continue. He wants Onder to give him an answer as to how his wife is. And Onder, I would say, pretty promptly does that. I mean, Onder first diffuses the situation, then they take a short break, and then when they come back, Onder is immediately telling him what happened. And I think that's pretty prompt in these circumstances. I see my time has expired, or is about to expire. I'd simply ask that you affirm. Thank you.
Mr. Parrish, rebuttal?
I'd like to go back, Judge Langholtz, your point on Smith v. Illinois. I agree. I don't think this court should chase rabbit holes in terms of analysis once they make a statement. And I don't think there's any prohibition to clearly saying, as Chief Judge Tabor said, he specifically asked, get me an effing lawyer, give me an effing lawyer, and then he says, I don't want to talk to you anymore. I don't know how much more emphatic any person could be without a education who can't read and write. That's sufficient for this court. On the harmless error, I want to follow up a little bit more on that and talk about how the state says it. I agree with you, Judge Tabor. There's no doubt part of this is going to get in. But then if you go back to the case I love, which is Walls, where they're debating this issue, the dissent, in just eloquent terms, they talk about the two-phase analysis of this. And in the two-phase analysis, they talk about what's the evidence that's going in. Well, you're going to get the second interview if you don't knock him out at the right to counsel issue. Could a prosecutor have gone in to interview him? Could they? Did the prosecutor know? Those are facts we don't know. But could a prosecutor have gone into the jail, the Winnebago jail, and interviewed him? I think not. So how can the agents do it? It's almost like a stretch of the Brady argument to get there. It passes down to your agents also. It wouldn't, Judge Batting, as you said, be just livid in that they did this. But that's why we believe it ought to be suppressed, because they knew he had counsel both on the 2nd of November and again on the 20th when Mr. Rigg entered his appearance. You don't just go in and complete those interviews. To talk about a different area of harmless, and again, I think this is a mixture between, as I indicated, the Parks case and the Walls case, is because you control the narrative. If it is suppressed, you can put the case may not be put in completely in the state's case, and the defendant has an opportunity to control the narrative. Maybe he didn't need the psychiatrist to come in at that point. Maybe he's going to use a different approach to defending him. Maybe he's just going to rely just on pure manslaughter based upon the first statement that's given, the partial first statement that's given. So you may not need an expert to come in. And then if you are going to use the strategy here, this is what will happen. He goes on, he puts his expert on after that. The state then would have to come back with rebuttal evidence. So the defendant does get a chance, if you rule that it should have been suppressed, to control the narrative a lot more. They're the one defending themselves from, in this case, second-degree murder. not only did they get a chance to control the narrative, but the opening statements are quite different. The cross-examination is quite different. The arguments to dismiss, maybe count one is quite, first-degree murder is quite different. Because he does show some degree of malice in the first part of his interview. If you separate them out, you can see the malice and the anger when he talks about, I wanted to see some papers, she's been taking my money, I get upset, I get angry, I smack her, and the officer says, well, you just smacked her in one, she just has one eye injured. This would have come in a totally different format than the prosecutor in this case being able to stand up and argue, well, this is what happened, this is what he said, this is his first interview, this is his second interview. These are all the things that he did. Well, clearly, he's going to look a little crazy at that point, and so does Mr. Mr. Cruz, to speak, because it's his life. Does he have anything differently that he can do at this point? So you narrowed his options down to almost zero at that point. So if you want to talk about harmless error, in a pretrial context like you did in Parks, it's significant, and the language in there really establishes, but the problem she had is that she went involuntarily. The court has already ruled, which you have to give deference to, that he was in custody. So you don't have the Park issue. Basically, you have a Walls issue where you have to balance out these things. Thank you, Your Honors.
Thank you, Counsel. Thank you to both counsel. Very helpful arguments today. We appreciate that, and the good briefing for both sides as well. We will consider 24-1954 State versus Cruz submitted, and we'll have a written decision coming as soon as possible. And we'll stand in brief recess while we have a panel change. Thank you.